Good evening and welcome to Adalat. This evening we have a very special program planned for you where we're going to talk about topics that we have never talked about before. In order to have a good discussion which is informative and useful for the community, I have two very special guests on the show, Anthony Okuma and Gurpreet Chadda. We're going to welcome them in a little while, but I just want to say that the law has changed a lot in England, particularly in relation to the English language. And it's really important that people who come to England learn English. Another change has just been introduced in immigration law, whereby spouses who were getting entry clearance to come to the UK had to pass entry level 1 English test. The change is that once they have arrived here, when they go for their next extension, they are expected to have improved their English and pass the test at a different level, a higher level to what they had to pass when they were simply coming here. The key to progress is that we have to move with the times. If we don't move with the times, we get left behind. So it is imperative that everybody in the community learns English. In England, there are many, many colleges, institutions, adult education institutions that offer English classes, and there is absolutely no excuse for not taking advantage of those classes, many of which are actually free for people. The Prime Minister has recently announced that he's going to give special help to 20% of women in the UK in a particular community who have no English at all. So for that reason, we are going to try and change Adalat into a more English-speaking show than other languages. But of course, it won't be wholly English-speaking. But when we have a guest who speaks only English, then we feel it's only polite that we stick to that language. Without any further delay, I would like to welcome my two guests into the show. Anthony Okuma, welcome to Adalat. Gurpreet, it's not your first time, but welcome all the same. Now, Anthony, I understand that you specialize in general civil litigation. And Gurpreet, I think apart from immigration, you also specialize in something else?
Well, predominantly we are doing immigration, but at the same time we do public law in the sense that challenging unlawful detention issues in judicial review, or if the client's removal is not reasonable, we are challenging that in judicial review in the high courts or upper tribunals.
And that's a really interesting topic, isn't it? That brings me to unlawful detention. And I know that you have some information about that to give to our viewers. Can we sort of open a debate about how unlawful detention actually takes place and what happens afterwards? And most importantly, what are the remedies for our viewers?
I think this is very important for our viewers to know that at what point of time the detention becomes unlawful. The starting point is that when an individual is detained by the Home Office or the Secretary of State, then initially they detain that individual because they think that if any case is pending, then that can be decided quickly. So his detention would not be prolonged further. Then second thing is if his removal or deportation can be enforced in a quick span of time. Now, when a person is being detained and his detention is ongoing and it's prolonging, then the first question one has to see whether it is reasonable for the Secretary of State to consider whether the removal would be possible within a reasonable time or not. The second is whether this detention review, what does it say, whether there is any risk of absconding, whether that risk of absconding is still continuing, and whether there is any risk of reoffending. Now, all these two issues are important that makes applicant or his legal representative to consider whether it is correct to continue detaining the applicant or whether he should be released. There are two ways. One is general, the applicant has got a right to apply for bail applications. And if detention becomes unlawful, then not only the applicant can challenge that detention in the High Court as a lawfulness of detention, and also if he proves that the detention is not lawful, then he's also entitled for compensation, which is like damages. So that damages remedy can be pursued separately if it proves that his detention is unlawful.
Okay, Anthony.
Yeah.
The first thing that comes to mind is the expenses. Now, of course, anybody can go and bring a case in the High Court, but we all know it's very expensive. And it's different from the Immigration Tribunal because you can sometimes be lumbered with very high costs of the Treasury solicitors as well. Would you like to tell us a little bit about how one funds these kind of challenges?
Yes. Depending on the merit of the claim, you can, with the firm I work with, obtain what is called a no-win, no-fee agreement,
Okay.
which essentially means that the firm will take on the work on the basis that if you're successful, you will be able to get your legal costs back from the Treasury solicitors,
Right.
i.e. the Home Office or the authority that did carry out the unlawful act. So that's one way of funding it. Of course, you can also fund it by way of paying privately to a firm of solicitors, but sometimes it may be difficult to be able to fund it. Like you rightly pointed out, it is a high court case. It could be very expensive. But the key thing is the merit of the case, the length of the detention to ascertain the damages that will be payable per se. Those factors will enable a solicitor to assess whether or not they can offer a no-win, no-fee to assist in running the case.
Now, this is very interesting, this term no win, no fee, because my understanding is that even then there are always some fees that are payable by the people who go to these solicitors. I mean, what is it really?
It is.
No win, no fee. I mean, if they don't win, do you really not charge anything at all, not even expenses?
The no-win, no-fee, you do have certain levels. You can have a no-win, no-fee whereby the client itself is liable to pay for the court fee, for instance, things
Right.
we call disbursements.
Right.
You could also have a full-blown no-win, no-fee whereby the client is not liable to make any payment whatsoever.
Right.
I think it's all on the merits of the case. It will
Okay.
all be dependent on the merits. I mean, most solicitors' practice may offer the full-blown no-win, no-fee agreement whereby the client will not be liable to make any payments if they lose. And if you're successful, the client's legal costs will be recouped from the Home Office or the Treasury solicitor or the government department. In some cases, it could be the Metropolitan Police Service who had actually conducted that unlawful act. So it could be any of the government agencies, and you could seek your costs from them if you're
Okay.
successful.
Wonderful. Now, I was very excited to hear that you also practice landlord and tenant.
Yes, I do.
Because, of course, that's something that affects our community very badly, particularly those people who are in social housing. So I was wondering if you'd throw some light on the whole housing area, particularly in relation to changes that have recently come in for landlord and tenant.
I think on the landlord side, the law had actually changed drastically. Just to give you some pointers without really going into much details. Every landlord that collects a deposit from a tenant must protect that deposit in a government-backed scheme. If you don't protect the tenant's deposit, you'll not be able to evict the tenant by way of a Section 21 notice. Now, the law has actually evolved more. It's changed from October 2015. Landlords have to give prescribed information, not just protecting the deposit, but they also have to give prescribed information to the tenants within a certain time limit. And if the landlord doesn't provide that information to the potential tenant or the tenant at the point of signing the contract, they will not be able to evict the tenant by way of a Section 21 or a Section 8 notice. And in fact, going further, landlords are now prohibited from evicting a tenant who makes a complaint to the local authority on a disrepair matter. So if the property is not in a good state and the tenant complains to the local authority who serves a notice on the landlord cannot evict the tenant. This is to do with retaliatory eviction, whereby some tenants will be evicted when they complain to the landlord about the state of the accommodation. The government has now changed this, so it is something on the part of the landlords they have to take into consideration when they take on a new tenant or when they're seeking to evict tenants. In respect of the tenants, I'm just going to run that very quickly. They need to be very clear about their rights. It's no longer the case that landlords can evict them fairly easy. They have to check whether the landlords had actually protected their deposit. If the landlord has not protected the deposit, the tenant can issue a claim against the landlord and obtain 3 times the amount of the deposit, which could be very substantial. And of course, the landlord has to have provided the prescribed information at the commencement of the tenancy. If the landlord had not given that information to the tenant can also not be evicted.
Right.
So it is
people
very
can be
drastic.
lumbered with problematic tenants.
Indeed.
For endlessly. Can I just ask a question there on behalf of the landlords who are watching?
Yes.
Does this apply only to new tenancies, or is it a retrospective provision which is going to apply to people who already have tenants in place?
The tenancy deposit scheme applies to tenancies that commenced in April 2007. So in
Right.
respect of protecting the deposit, but in respect of the retaliatory tenancies, in respect of the prescribed information, in order to, when I mean the prescribed information, I'm referring to the checklist which has to be provided to the tenants, and that only starts from tenancies entered into in October 2015, last year.
So it's very recent.
It's quite
What about
recent.
people who've had tenants for like 2 or 3 years and it's ongoing? Do they need to comply with these
As
formalities?
long as the tenancy agreement has not been renewed, then there's no requirement to provide the prescribed information.
Right.
But assuming you've had a tenant for the past 2 years and you've renewed the tenancy from October 2015, you have to comply with the requirement of
Right.
providing this information. So for
Even
landlords,
renewal?
even renewal,
Not
yes,
just taking on new tenants, but every time you renew
you have to
a
give them
tenancy agreement.
you have to give them a checklist to confirm that they've received that before you, and you have to protect their deposit.
So this applies pretty much to all landlords in that case,
Indeed.
because all landlords will probably be renewing the tenancies. of
Some
the
might just be going on a statutory periodic tenancy when the fixed term had ended,
Right.
and they don't want to renew. I mean, they
Right.
can be on a statutory periodic, but
Right.
when that tenancy is renewed and you enter into a new term, then you have to obviously make sure. I think the advice to landlords watching the program is, look, check your tenancy agreement, check that you've protected the deposit, which is very crucial, and make sure you're compliant, because the sanctions could be very expensive if you
Right.
don't comply.
Okay, wonderful. What about other areas of housing law? How difficult is it to obtain a social housing? Are the queues very long still?
It is very long. It is quite difficult because the local authorities are inundated with, I think they have what I call the gatekeeping policy. They try as much as possible to make it difficult for people to be able to access social housing by throwing up hurdles. And I think the reason being, especially for London, the housing is
a
quite an
problem
issue.
anyway, yes.
But I always say, if you have a genuine case, make sure you push for it, because there is still housing there, and tenants.
Is there, one gets the feeling that London is overcrowded already?
There is still adequate housing, but it's
Really?
quite limited. And of course, the local authority are inundated with requests. So the general advice I will give is for people in that situation to push, get legal advisors, speak to their MPs, speak to their local councillor, push for it, and if your case is strong enough, you will get housing.
So what kind of cases do you normally get in your housing area of legal practice?
I
What are
think-
the problems people have?
I think the big problem, especially for the community that were watching the program, that we tend to have is homelessness.
Homelessness.
There is quite an issue whatsoever if you have a marital breakdown and you need to move out of your marital home and you're seeking assistance from the local authority. There could be issues assessing those services, like getting adequate housing. We do see that quite a lot. The decision-making process for a homelessness application could be very cumbersome, because the local authorities sometimes use the same brush on every application. Sometimes they do make mistakes, which we can review those mistakes by way of asking for perhaps a judicial review, or taking it to a county court judge to look at the reasonableness of the decision made. The key thing I always say is make sure that the case is well presented, you give all the information to the local authority, so that you could at least stand a better chance of getting that sort of assistance in terms of homelessness. We also see a lot of possessions on the landlord side, where the landlords have not complied with the protection of deposit. That obviously derails everything, because clearly they cannot proceed with the possession since they fail to protect the deposit. And also they run a risk of getting a court order to pay 3 times the deposit. So my advice to landlords will be, make sure that you've protected your deposit. Make sure that if the tenant contacts you about any disrepair, that you try as much as possible to look into that and resolve it before it gets out of hand. It could cost you more if you don't deal with it.
Right. And then in this general area of civil litigation, can you explain to our viewers what exactly is civil litigation?
It is quite broad.
It is broad.
It is very broad.
A general.
Generally speaking, civil litigation deals with any dispute between individuals or corporates or between an individual and the state. I mean, my colleague here deals with a bit of litigation when we work on unlawful detention. So insofar as what I deal with specifically, I think maybe if I explain what I do,
yes,
because I don't want to put it, then I deal with areas such as professional negligence, where you have disputes between your professionals. Say, for instance, the solicitor doesn't give the proper advice to the viewers, then there is a remedy to be able to bring that professional to account by way of bringing a claim against that professional for damages. I also deal with matters pertaining to debt recovery, whereby people who are owed money I could assist them in pursuing the...
I better talk to you after the show
yes.
in relation to solicitors, actually.
Yes. And I predominantly also deal with property litigation, service charge disputes.
Okay, I'm so sorry, but we are going to a break now, but we'll be back and we will continue this discussion further. Keep watching Venus TV.